Okay, just a word of reminder, if you could please silence your cell phones so we don't have distractions during the arguments. And I am now going to turn it over to Chief Judge Jenny Rivera.
Thank you. Good afternoon. On our calendar today is Fitisimano v. United States. Petitioners?
Mr. Chief Justice, and may it please the Court, the 14th Amendment is unequivocal. Citizenship does not depend on race, status, or the particular geographic region of the United States in which a person is born or lives. Justice Harlan's famous dissent in Plessy recognized that the 14th Amendment added greatly to the dignity and glory of American citizenship. This greatness was intended by the framers of the 14th Amendment to apply not only to white Americans, but to all races. Yet, American Samoans born in a United States territory, which is in the United States and subject to the jurisdiction of the United States, are denied birthright citizenship. They are instead declared by Section 14081 nationals, but not citizens of the United States, effectively making them citizens of nowhere. This statute is unconstitutional and has no basis in the common law tradition.
So, counsel, can you address what would be the textual reading of the Constitution, given that the amendment that you're referring to, of course, says United States. It does not refer to the territories, and when the Constitution refers to the territories, it does so explicitly.
Thank you, Justice Rivera. So the text is actually far from ambiguous. The words of the 14th Amendment, as it was founded by the framers in the Citizenship Clause, when looking at the historical evidence, actually meant that all persons born and naturalized in the United States, subject to a jurisdiction, therefore, are citizens of the United States. In that basis, the conception United States actually referred to a geographical textual meaning of those words. Now, what happened as a result of cases such as the insular cases, which had
Before you get to the insular cases, let's stay with the first point you were making. But isn't the geographic reference you're making to those territories that were within the continental U.S. as opposed to territories that are external to the continent?
So that is actually a misconception of the way in which these, the conception of jurisdiction or the geographic regions were understood. So initially, the conception of the United States under the 14th Amendment meant anything under United States soil, hence the jus soli conception of citizenship, which borrows from the English common law tradition of jus soli. And we look at this from the cases such as Calvin's case of 1608, in which the birth, for instance, of a citizen or a Scottish national within the king's jurisdiction or dominion and pledging allegiance to the king was therefore deemed as a citizen subordinate, or rather a subject to the king's jurisdiction. So that's very much the conception of this common law tradition.
What territories were outside at the time of the amendment? What territories were outside the continental U.S. that were within the jurisdiction? Does that inform the way we should think about the meaning of the amendment and the provision you're referring to?
So when we actually look at the textualist meaning through contemporary evidence, not just through the original public meaning, but also through the public understanding of this, through dictionaries, maps, atlases, and censuses at that time, territory was defined, for instance, by the Law Dictionary of John Bouvier as a portion of the country subject to and belonging to the United States. So that implied a territory. Then we look at the Bouvier Law Dictionary again, in which it says the United States of America was a nation occupying the territory between British America in the north, Mexico in the south, the Atlantic and the Gulf of Mexico in the east, and the Pacific on the west. We look at the maps as well at the time, which included all territories, even unorganized territories that were not destined for statehood at the time. actually at the time of the ratification of the 14th Amendment, this conception of incorporated, unincorporated territories did not have any existence or did not have
But
any.
then why does it refer to United States? Why not just say any area, any person subject to the jurisdiction? Why have the first provision that refers to the United States?
Well,
Is it superfluous?
Actually, what in the textualist conception of it, the states of the United States, or rather, states of the Union, referred to the states specifically. United States referred to the United States as a country, therefore a country that was able to confer citizenship, whereas states of the Union referred specifically to each individual state, which differed from the federal conception of the United States.
Counsel, on that point, how should this court, the definition of citizenship, how should this court consider the uninterrupted historical practice that is Congress, not this court that this question is brought before, that determines if and when people born in the United States territories are recognized as citizens?
So with regards to this uninterrupted process or precedent in which the way court has looked at territories, we say that this is the wrong conception in the manner of looking at territories. We want to revert back to the original meaning of the 14th Amendment, which very much looked at conferring citizenship beyond the conceptions of race, beyond the conceptions of status, beyond the conceptions that were independent of the geographic scope of what citizenship meant. So with regard to disturbing that precedent, we say that actually that precedent should be overturned because the insular cases had set the wrong type of precedent and meaning which runs contrary to what the original understanding of the 14th Amendment ought to be, which is the jus soli doctrine or the common law tradition of birthright citizenship.
So is it your position that the court should disregard this historical practice and confer a meaning of citizenship even when you're faced with American Samoans as citizens where their own leaders are opposing the conferring of citizenship? We should disregard that, and this court should impose that definition.
So my colleague in the amici will actually discuss further what the American Samoan position is. What we'd say is we are addressing the current harms of the lack of citizenship for American Samoans. They have in their passport, for instance, a note that says that they are not citizens of the United States of America and therefore not citizens of anywhere. They are not allowed to vote, for instance, within the United States elections. They are not allowed to hold specific positions of office. That is the harm.
Do they not have a somewhat easier pathway to citizenship? Has not Congress provided that for American Samoans?
So,
If they are so interested, is not that the better approach? Those who want citizenship can seek it. Those who do not, status quo or some other form of self-determination. Isn't that the better, fairer balancing of all of these interests?
we'd say that actually naturalization is the harm. It's not the remedy in this situation. Just because an individual is allowed to naturalize, they shouldn't have to go to a process that they should be conferred with from birth. And we'd say that actually going through that process, as someone who has gone through the process of naturalization myself, would say that it's an incredibly tedious, difficult process. It creates a great deal of uncertainty. The amount of time it takes for anyone to be naturalized is largely uncertain. And within that period of time, there is incredible prejudice from the very get-go that should have been dealt with from the birth of that citizen, they are Americans.
But when the tribal leaders ceded the country to the United States, they could have negotiated that, and they did not. Aren't we then back to the same problem that the people, and perhaps these representatives now of the people, are opposed to the very argument and position that you are taking, which leaves us in this very difficult position? I'm not disagreeing with you about the challenges of naturalization.
So from the very matter of secession, actually my partner will deal with that in better detail, but the tribal leaders actually understood by ceding their territory and voluntarily doing so that they would be citizens of the United States of America. This is what was understood at that point, and to their surprise, and to the surprise of, I presume, many territories that had to suffer through these consequences, they were conferred in a desire to increase the scope of an American empire with that lack of citizenship, which they willfully thought they were promised in making that bargain. So we'd actually say that we're returning a remedy to the situation in which they thought they ought to have, or the powers that they thought that they ought to have upon the conferral of their citizenship.
So Counsel, does the Constitution allow for the permanent creation of a non-citizen?
This, I think, is a myth. This concept of a non-citizen is a myth in understanding what a national is rather than what a citizen is. And I think that myth is perpetuated in the case of Gonzalez, for instance, in which there was an attempt to sidestep the question of who is a citizen and who is not a citizen of the United States of America, instead sidestepping it by saying that Gonzalez was merely a national. But actually, when we look at the real question at stake and what's at stake with the question of citizenship, we'd say that that has far more power and authority in granting a fundamental right to an individual, in conferring to them citizenship rather than nationality. So we'd say that the 14th Amendment itself, and its language and its plain meaning, talks about citizenship, not only from a textualist level, but from the, as I had already mentioned, in the original public meaning and a public understanding through contemporary evidence, through dictionaries, maps, atlases, and census. And in fact, when we look at the purpose of the citizenship clause itself, its intention was forever to close the door on Dred Scott and constitutionalize the Civil Rights Act of 1866. It wanted to declare that all persons born in the United States are not subject to any foreign power.
Counsel, can you address how Wong Kim Ark is not distinguishable, given that the individual there was born in a state?
So the question before Wong Kim Ark is, yes, we can see that it is based on an individual born in the state at the time. And so the respondents try to distinguish that case and say that therefore they're not conferred, but this doesn't apply in this matter. But actually, when we look at the ratio or the meaning behind Wong Kim Ark, the legal reasoning itself relies heavily on the conception of birthright citizenship being tied to a common law tradition of land jurisdiction use soli. It can't be that these comments were merely obiter when the very case of Wong Kim Ark actually rejected the jus sanguinis doctrine in favor of the jus soli doctrine and looked at citizenship as something tied to land. And to basically say that something like a territory like American Samoa, because it's a territory, is not part of the United States is simply false. It is part of the United States geographically and within the United States scope.
Counsel, can I just to get back to a question my colleague asked regarding citizenship and the issue of naturalization? So the just result of your argument is that citizenship should be conferred upon American Samoans, even those who don't want citizenship, because there is opposition, versus the American Samoans in, say, Utah, in this case, applying for a beneficial or fast-track naturalization. Is that your position?
Opposition is that we're not taking away the right of American Samoans to have self-determination. We'd say that if they want independence as a territory of the United States, whatever that might entail, that is up to them to decide. This doesn't remove their right to grant independence. What we're remedying is actually the current position that they ought to have at this very moment, the very harm that they're experiencing, in that they are not conferred with any citizenship whatsoever. They can't have American Samoan citizenship because American Samoa as a country doesn't currently exist. So at the moment, what they do have, and what they ought to have under the 14th Amendment, is American citizenship. And if they want to be granted independence, that is a separate question for the people, and we do not want to remove that right. But actually what we're trying to say...
And so let me ask you this. Let's say we ruled in your favor, and tomorrow they're all American citizens. and then they hold a referendum, decide we don't want to be American citizens, what would happen?
That would just be a case like the Philippines, for instance, which was able to get independence, is self-governing at this very moment, and does not rely on the United States, apart from when the United States wants to support the Philippines in its military ventures.
And to those who would have voted against the referendum, right, and who want to keep their citizenship, what path would they have available to them? Would Congress have to step in then and say, we'll still recognize those who want to be citizens, or we'll maintain the path to citizenship through naturalization? What would be the outcome of that?
We'd say that that's a matter for the legislature about what independence will look like. In terms
The American, the Samoan legislature, is that what you meant? Or Congress, I'm sorry.
So within Congress and the American Samoan legislature, and a discussion on the rights of territories, such as American Samoa, to grant their own, to have their own referendum in the first place. So that would be a matter for Congress to deal with. But
Counsel, do the insular cases need to be overturned in order for your clients to prevail?
So we don't think that the insular cases, I understand I'm out of time, but
No,
the insular
finish your
cases
answer.
necessarily need to be overturned in this case, because we're looking at the plain meaning, the original understanding, the textual meaning of the 14th Amendment. But we'd say, and as various justices of the Supreme Court, such as Justice Gorsuch, Justice Sotomayor, have said in their concurrences to Valle Madero, now is the time to really address this issue. It's up to the Supreme Court to declare what the law is. And this is the 14th Amendment. This is a question of constitutional concern, and therefore we should revert back to what the real meaning of the 14th Amendment is, and take this as an opportunity to stop extending the 14th Amendment.
Thank you, counsel.
Thank you.
Amici for petitioner, please.
Thank you, Madam Chief Justice, and may it please the Court. Otola Regi Bean for the petitioner's amici. If Congress wanted to keep the birthright citizenship question for U.S. territories in the political realm, it could have done so. Instead, as this Court made clear in Wong Kim Ark and Afroyim, the Citizenship Clause places that question beyond the legislative power. But the respondents asked this Court to ignore the Constitution and permit Congress to deprive American Samoans of their fundamental right as a means of preserving cultural heritage. But the lower courts have shown that the project to reconcile local traditions with constitutional guarantees is already well underway and succeeding in the territories. This Court should reverse the court below and recognize birthright citizenship for American Samoans for the following two reasons. First, the 14th Amendment forecloses Congress from dispensing citizenship as a favor to people in the territories. And second, the experiences of the other four territories clarify that birthright citizenship is compatible with their way of life and institutions. First, the birthright citizenship question cannot be made subject to a democratic process as the government and interveners demand. The Citizenship Clause preempts that possibility because the framers of the 14th Amendment intended for that question to exist outside of politics. This Court affirmed that intention in the slaughterhouse cases, Wong Kim Ark, and later in Afroyim. Gone are the days where a temporary legislative majority or civil war even could deny the citizenship rights of people born in the territories simply for the color of their skin. Did you also have a question, Justice?
Not yet. No.
Okay, sorry.
Not yet.
And really, what the government and interveners request of this Court is in direct opposition to what the framers of that amendment desire. American Samoans' own history further cautions why this Court cannot accept the respondents' argument. Because for over half a century following the territory's annexation, an overwhelming majority of, American Samoans had an overwhelming desire to become U.S. citizens. And in fact, there was an understanding for that time period that citizenship was entitled to them because of their secession. But it was Congress that time and time again denied them of this fundamental right. And this is exactly the type of situation that the framers of the 14th Amendment were concerned about.
Counsel, on that point, your colleague left this question for you, so I'll ask it to you. Why should the Court recognize American Samoans as citizens when it's the American Samoans' own leaders who have an opposition? Shouldn't we listen to those who are to be affected by this ruling?
First, Your Honor, it's important to clarify that this issue is already settled and that essentially this is something that the American Samoans people's ancestors gifted to them during the time of secession. But even if that was a relevant consideration, we hold that, really the trajectory of the consensus going from being overwhelming to much more contested has a lot to do with general misunderstandings about what birthright citizenship entails. And it's the experiences of the other 4 territories that clarify that birthright citizenship can and does mesh with a territory's right to self-determination, their legal traditions, and the preservation of their cultural heritage.
Well, I'm a little confused. That matches with self-determination. Then they can just pass a referendum, no? And it appears that they object. So how does that match? I'm having a little bit of difficulty following that argument.
Well, Your Honor, the question of the citizenship status of people in the territories and the question of the future political relationship with the United States and the territory, those are 2 separate questions. And the experiences of Puerto Rico and Guam are particularly instructive. So following the statutory recognition of birthright citizenship in those 2 territories, the people in both of the territories underwent several, in Puerto Rico's case, 6 non-binding referenda to clarify what their future political status was with the United States. And the citizenship status of the people taking part in those debates was immaterial. And there's nothing to suggest that following this court's recognition of the birthright citizenship for American Samoans, that their citizenship status would prevent them from having these conversations and even integrating them into their constitution as the people did in Guam. But to the point of really what the interveners are concerned with, it's important to recognize that it is American Samoa's territorial status, not citizenship, that perpetuates the colonial structures that the government officials rightfully protest. And that citizenship and its political benefits would actually provide further agencies to American Samoans in clarifying their relationship. So we actually would hold that.
But aren't you really making it even more obvious that this is a question for Congress, not this court? We're sort of talking about the politics behind it.
No, Your Honor. So I think this is not, I think it's first important to clarify that this is not a political question. And so as this court said in Wong Kim Ark and later in Afroyim, that the citizenship clause, and specifically the clause's framers, put the question of citizenship and the rights of citizens beyond the legislative power. It's when we make this question a political issue,
So if I'm understanding, then you and counsel for petitioner, the position that you're both advocating is this court decides what the Constitution means, of course, and in this case what the Constitution means is they're entitled to birthright citizenship. They don't get to decide that, but they get to reject citizenship. That's the part of self-determination, that they could the very next day start a process to reject citizenship. Is that correct?
Yes, Your Honor, if that's indeed what they wanted. And it is the recognition of citizenship would not quell those conversations. It would not. We do not expect them to alter them.
And is it your position that the people of American Samoa, since they'd have citizenship, would be the only ones engaged in that discourse? Or would Congress also have a role, say as something as basic as deciding the procedure by which to decide whether or not to reject citizenship?
I'm sure that this would be a collaborative process, Your Honor, between the federal legislature and the leaders of American Samoa, honestly, as it should have been during the time of secession when the leaders of American Samoa were requesting that their citizenship was acknowledged.
But the reality is, if you want something that bad in your contract, this case, secession, right? We'll just call it secession because that's what it was. Would you not have withheld the land agreement, the control that you're ceding to the government of the United States until you got an express written recognition of citizenship?
Well, actually, Your Honor, there was a very realistic expectation that where the flag of the United States is planted, the constitutional provisions apply. So it was not unrealistic for the leaders of American Samoa to expect, as they did, that they were entitled to birthright citizenship and that they were indeed U.S. citizens following secession. It was Congress, on the other hand, who was acting in direct opposition, not just to American Samoans, but to the very Constitution and the framers' intent by denying them of their fundamental right.
Counsel, you referenced the other territories, the other 4 territories, Guam, Puerto Rico. It was Congress that conferred citizenship on these territories. But you're asking the court to confer on the American Samoans, correct?
No, Your Honor. So Congress statutorily recognized birthright citizenship, and actually why the amici representing the 4 territories, who I'm counsel for, are a part of this conversation is because by not clarifying that their birthright citizenship comes from the 14th Amendment and does not point to those statutes, we have a situation where Congress can take that citizenship away, as this court said in Afroyim. But as we know and as we're arguing, the Citizenship Clause grants all of the people born in those territories birthright citizenship. So really, those statutes are not necessary. Congress does have the power to clarify a constitutional provision. What we're more concerned about is Congress deciding tomorrow that they wanted to deny citizenship to the people of Puerto Rico, Guam, the Northern Mariana Islands, and the Virgin Islands, because that cannot be the case.
So, counsel, certainly when you talk about the different territories, different customs and cultures. So are you asking this court to create a uniform rule for all of the territories in spite of the differences that exist between them?
Well, Your Honor, what we're asking is not necessarily for this court to create a uniform rule, solely to acknowledge that each of these territories is entitled to the recognition of their birthright citizenship. When it comes to considering the nuances that exist across the territories, the jurisprudence in the courts, both in and with respect to each of the territories, has already underwent processes to reconcile those local traditions with constitutional guarantees. And an example of that is actually in American Samoan's own high court, in the Craddock case, where there was an equal protection challenge to the territory's race-based land alienation law. And rather than relying on the constitutionally insecure territorial incorporation doctrine, the high court used a strict scrutiny standard to protect that law and stave off that constitutional challenge. This is commonplace across the territories, and if there's concerns about political institutions, Congress has broad latitude under their Article 4 plenary power to address those concerns. And in fact, there is much power and really an onus on Congress to implement innovative approaches to take into consideration the needs of the residents of the territories that this court has affirmed time and time again. And when it comes to the preservation of cultural heritage, the experiences of Guam and the Northern Mariana Islands are instructive because the statutory recognition of their birthright citizenship, it can be argued, gave them broader latitude to maintain their distinctive culture and identity. So, throughout the time under the American...
Can you drill down a little bit on that point?
Yes, Your Honor.
How is imposing something still recognizing a unique, distinct culture?
Well, Your Honor, we would push back that the recognition of U.S. citizenship isn't imposing something. It's simply acknowledging the intent of the framers. But what each of the territories demonstrate is that birthright citizenship is compatible with their way of life, with their culture and their customs, and that when we don't acknowledge birthright citizenship, it actually causes more harm than it does good.
Well, let me ask you this. Let's say there's a typical cultural doctrine, for lack of a better word in this moment, that is well known, well understood, a way that the community functions that is in conflict with whatever we might say is a core doctrine, principle of our Constitution. What would control in that sense?
Well, Your Honor, it would depend on the constitutional provision, but taking your example further, if this is a scenario where, say if it's an equal protection challenge and it's found that an equal protection analysis would unfortunately render this practice moot, then we would have a situation like we did in the Northern Mariana Islands, where the territory can negotiate with Congress to have that custom protected in its covenant with the the United States. And just taking the Northern Mariana example.
So if I'm understanding that argument, you're advocating for a status of citizen who nevertheless has to have some negotiation with Congress to be able to exercise their culture.
Well, Your Honor, that was essentially Congress's commitment to having these negotiations and to accommodating the territories was a part of the secession. And what we see specifically in the covenant.
But doesn't that inherently mean you're not really talking about citizenship? You see my issue? It sounds to me like there's citizenship, and then you're looking at a particular type of citizenship for American Samoans. And I'm having difficulty finding the genesis of that in the Constitution. Because it sounds like it's not just, I'm a citizen of the United States. I don't get to negotiate my Puerto Rican culture.
And I think that's attributed more so to, it's not attributed to the citizenship question, but rather to the simple fact that at the end of the day, American Samoa is a territory. And so this issue implicates their territorial status, not their citizenship rights. But if I may wrap up, if there are no further questions, neither the people nor Congress can deny what the Constitution has already granted. American Samoans are constitutionally entitled to U.S. citizenship under the 14th Amendment. And then finally, to echo my colleague, counsel for the petitioner, the court should overturn the insular cases and an irredeemable line of cases rooted in open bigotry, not constitutional text. And the insular cases belong in the dustbin of history alongside Dred Scott, Plessy, and Korematsu. So for these reasons, this court should reverse the lower court's decision and recognize birthright citizenship for American Samoans and people born in the territories.
I know it says stop, but I do have a
you.
question now that you said that. Be careful what you wish for. Hopefully I won't forget the question. So given what you've said, it would be hard to argue with you that there's language in these insular cases that is anathema to us today. Should have been then, but certainly to us today. And that this court should never rely on that language in the future. So one cannot argue that. But is there a way to maintain the territorial clause distinction that has survived even that reprehensible language today? Is there some aspect of the reasoning in those cases? It hasn't got to do with alien races and their inferiority and the racism. Is there something else that can withstand now some kind of legal analysis?
In the insular cases?
Yes.
No, Your Honor, because we would argue that when the premise of a line of cases is bad, that everything about those cases is irredeemable. And so rather than relying on these constitutionally insecure cases, which only provide protection where the Constitution doesn't apply, and as this court said in Ariulis, the Constitution does apply, we would direct the courts to refer to, or to simply use the tools at their disposal, which are normal constitutional law principles. Thank you.
Thank you. Okay. All right. Counsel for the United States, please. Yes. Be there here. Oh, maybe not. Okay, really. Come up here if you want.
May I proceed?
Yes, sir.
Thank you, Your Honor. Madam Chief Justice, and may it please the Court. My name is Parker Chussett, appearing today on behalf of the federal respondents. The core issue in this case is whether the plain language of the 14th Amendment extends birthright citizenship to non-U.S. citizens born on the unincorporated outlying possession of American Samoa. Because American Samoa is not in the United States for purposes of that amendment, automatic birthright citizenship can be extended only through congressional action. This court has never held that the 14th Amendment confers birthright citizenship on inhabitants of unincorporated outlying possessions, and it should not do so now in the face of a century of historical precedent, ongoing cultural and political disputes, and the availability of statutory solutions. I'll make 2 points. First, the term the United States, as it is used in the Citizenship Clause, does not include the territories, or at a very minimum, is ambiguous and should be resolved with regard to the unbroken century of precedent. And second, as the brief for scholars of constitutional law and legal history acknowledged explicitly, and as counsel for petitioner just acknowledged explicitly, this case does not turn on the insular cases, and a re-examination of those cases is not properly before this court. Turning to my first point, it is helpful to compare at a textual level the language of the 14th and 13th Amendments as they're ratified in the same era. Whereas Section 1 of the 14th Amendment refers only to persons born or naturalized in the United States, the 13th Amendment explicitly says it applies within the United States or any place subject to their jurisdiction. Furthermore, even intratextually, the Citizenship Clause points towards reading the United States as the states united. It concludes that its objects are citizens of the United States and of the state wherein they reside, not if they reside in a state, but wherein they actually do reside. We can see a similar textual note back in the 13th Amendment.
What about the territories within the continental U.S., historically at the time?
Historically at the time, Your Honor, that would not have been a part of the United States at that time, as they were not states. They should be understood.
But anticipated to be on their way to becoming, the areas becoming either many states?
Yes, Your Honor. That distinction turns on the insular cases, and our argument today is that that distinction is not relevant to the resolution of what is or is not the United States, but is relevant to the question brought about in the insular cases themselves, which is the distinction between unincorporated and incorporated territories. The United States, as it is understood in the Citizenship Clause, refers not to territories.
Well, Counsel, as your definition, I believe your term is United States are within the Union of the continental United States, correct? And in terms of the Citizenship Clause, does it only include states of the Union? And what does that mean for those born in the District of Columbia?
Yes, Your Honor. I would have two answers to that question, one of which is historical and the other which is textual. The historical one is that we can see that the District of Columbia was carved out of other states, and the textual one is that that happened because we have the District Clause in Section 1 of the United States Constitution explicitly telling us to carve out the District of Columbia from other states and imbuing it with the citizenship of the United States.
So what is do you draw a distinction between people born in incorporated versus unincorporated territories for the purposes of the Citizenship Clause? And, or does that distinction not matter for birthright citizenship?
That distinction is unimportant for the sake of birthright citizenship, Your Honor.
Right. So in this case, the plaintiffs reside in the continental United States, pay taxes, but don't have the rights that a citizen would have. Is that correct?
Yes, they do. That is exactly right, Your Honor.
And that is solely based on where they were born. Is that correct?
Yes, Your Honor. Like anybody else born outside of the United States, anybody born in France, for example, they're treated as not having been born in the United States. They're not a citizen.
Thank you.
Now, counsel, you indicate that we should not address the insular cases, but if we do, what should take place?
Your Honor, should this court decide to address the insular cases, despite a lack of adversity between the parties, it should address it in the same way that this court referenced them in Boumediene, for example. It should have a narrow conception of the insular cases as a historic precedent that is narrowed to the scope of their facts and not extended beyond that.
So in other words, you are saying we should not take this opportunity to overrule the insular cases. Is that the position of the United States?
Yes,
Do not overrule the insular cases?
Yes, Your Honor, that is the position for two reasons, as I mentioned. The first of which is that it is not important to the resolution of this case. It is whether this court, how this court addresses the insular cases. It does not change the outcome of this case in any way, and so it's not properly before the court. And second, because we think they should be narrowed to their facts, Your Honor.
Let me go back to your example about France. France is its own country. People are citizens of France. But as counsel has already pointed out, they don't have a citizenship. Isn't that a distinction that we should take into consideration in this analysis?
It is, Your Honor, and I
Okay.
think that we do take that into account in a number of statutory measures. The counsel for petitioner mentioned spoke at length about the difficulty of the naturalization process in the United States. The U.S. Congress has seen fit, in cooperation with the government of American Samoa, to enact different naturalization statutes for nationals of American Samoa in order to ensure that that process is relatively streamlined for those nationals, different than for a national of France, for example, Your Honor.
But why not just let them check a box? You want to be an American citizen? There you are. Why go through any other process?
Your Honor,
They're being measured differently, are they not? Solely because they're born in American Samoa.
that is correct, Your Honor. They are being measured differently because they're born in American Samoa as opposed to having born in the United States. That is the nature of birthright citizenship as a concept, that it extends from the place of one's birth.
Let me ask you this. What would be an example of a basis to reject an application for naturalization by someone born in American Samoa?
A constitutional or statutory basis?
No,
Your
no,
Honor?
statutory basis.
Your Honor, to be perfectly frank, I'm happy to brief this issue, but I'm not familiar with the specifics of why an application would be rejected. I think that question actually points us to a larger theme in this case, however, which is that the specifics of how to address individual applications for citizenship, and the problems in that we have here the government for American Samoa representing the majority of the American Samoan people, telling this court that it is not the position of that majority that they desire citizenship, but we do have individual nationals of American Samoa who desire that citizenship. That points us towards a political resolution, which we can see as being ongoing, and that there are statutes differentiating between nationals of American Samoa and and nationals of France, Your Honor. That distinction and the ability of the political process to address those fine-grained problems as opposed to sweeping with too broad of a brush, as this court would be forced to do as it is in its interpretation of the constitutional text.
Can you address your adversary's argument that there was an expectation at the time of cessation that citizenship would run with giving up the land to the United States government?
Your Honor, that is not my understanding or the United States government's understanding of the history of American Samoa. The counsel for the interveners might be better positioned to address that at length. Okay. However, my understanding of that is that we have the text of the agreement and that was explicitly not included in it. I think that we can also see, and perhaps this is somewhat helpful, that in all of the other territories there are statutes explicitly granting citizenship, and that some of those were in place prior to the secession of American Samoa, which would have been a building block in how we would construct the relationship between the American Samoan people and the United States. I want to address a couple of points made.
Counsel, can we go back? I started to think about your response about France, right? And I've been sitting with it for a while. You know, a person born in the American Samoa has the same rights as someone who was born in France, correct? According to your position, the government's position.
With the exceptions that I point out with regard to the naturalization statutes that the Congress has seen fit to pass. Yes,
Okay.
Your Honor.
We'll take that for now. But a person from France is not conferred an American passport with a stamp that indicates not a citizen but a national, correct?
Yes, Your Honor, that's another benefit that the Congress has seen fit to confer upon American Samoan nationals.
So American Samoans are not like French. They're not French folks. They're of a territory, but they're treated slightly different, maybe largely different, just because of where they're born, correct?
Yes, Your Honor.
So the difference between someone being born in American Samoa and Utah is literally between American Samoa and Utah. There's nothing different.
Yes, it is based upon the geography, yes, Your Honor.
And should we not take that up as being just unjust to those in American Samoa? Someone born in American Samoa?
No, Your Honor. And I think that this actually, this connects with the point that I wanted to make in response to a point made by counsel for petitioner with regard to Wong Kim Ark. In Wong Kim Ark, we've mentioned at numerous points throughout our briefing that Wong Kim Ark is disanalogous to this case because the petitioner there was born in San Francisco. And I think that that does create the disanalogy sufficiently. But the point that we're making there is that the court in Wong Kim Ark was not addressing its definition of the geographic United States. What it was addressing, because everybody acknowledged he was born in the geographic United States, that wasn't at issue. What was at issue was if, despite that, on account of his, that he had Chinese parents, that he was not white, that he was not an Anglo-American, that if that was enough to mean that he was subject to some foreign sovereign and under some versions of the common law tradition was therefore not eligible to be a United States citizen. The court in Wong Kim Ark explicitly said that that argument cannot fit with our conception of the 14th Amendment with the Citizenship Clause because the Citizenship Clause is meant to be an exclusive focus on this geographic scope, not, Your Honor, on who these people are, what race they are, but simply where they are born. Are they born in the United States? They're citizens. Are they born outside of the United States? They're not.
But in that particular case, the individual's parents were not in a territory, they're in a separate country. So what about the allegiance of the American Samoan people to the United States? Is it the government's position that they owe no allegiance because they are not citizens?
Your Honor, it's not our position as a formal matter. The American Samoan people serve in the United States military and are exemplary members of the United States as a polity. Our contention is merely that on the basis of the constitutional text, that with the enactment of the 14th Amendment, we did not force the American Samoas to swear allegiance and to become citizens of the United States, but instead allowed that to survive through the political processes.
Yeah. It does, following up on my esteemed colleague's point about justness, what is just, it does seem a bit odd that one can shed blood and treasure and not be a citizen, no? You can serve in the military, die in the military, and yet have no citizenship recognition, and have, even in a perhaps a more flexible and perhaps more streamlined, I think you used that word, process for naturalization, nevertheless have to go through a hurdle that no one else has to go through, and again, have particular allegiances and commitment to the United States. It does seem odd and unjust. Certainly, there is an argument to be had that it is against our principles, our core principles, no?
Absolutely, Your Honor, that argument is to be had, and Your Honor, I would make the point that all of the other territories of the United States have worked with the United States Congress to pass statutes on that basis and based upon that reasoning that confer automatic birthright citizenship to their nationals, and that the American Samoan people have decided that it is not in their best interest to work in order to achieve that same goal.
Counsel, I noticed that in your brief, you don't even discuss the common law understanding of birthright citizenship. So should we just ignore the common law? Or if not, what should be the understanding with respect to birthright citizenship to support your understanding?
Your Honor, our understanding of the common law basis for birthright citizenship is actually almost exactly the same as articulated by counsel for petitioner in terms of that we refer to Wong Kim Ark. The difference is that we actually, and I apologize, Your Honor, I realize that I've gone over
answer
time.
the question.
That Wong Kim Ark did not resolve the question of the geographic scope of the phrase the United States. What it resolved was that in interpreting birthright citizenship within the scope of the United States, do we look to jus sanguinis? Do we look to the parentage of the person who's born in the United States in order to determine whether they have some foreign affiliation to some foreign sovereign to whom they owe allegiance? Or do we simply ask, in accordance with the 14th Amendment, were they born in the United States? That's what this court decided in Wong Kim Ark, and that's what we would ask this court to continue to decide here. Thank you, Your Honors.
Thank you.
Thank you.
All right, thank you. Yes. Yes, Counsel for American Samoa, please proceed.
Good evening, Madam Chief Justice, Your Honors, and may it please the Court. My name is Nikita Ganesh, and I represent the democratically elected leaders of American Samoa. For 3,000 years, on an archipelago 7,000 miles from this court, the American Samoan people have worked tirelessly to preserve Fa'a Samoa, the traditional Samoan way of life. Part of preserving this traditional status has been due to their unique political status. Since the time of voluntary secession, the American Samoan leaders worked to preserve the people's status as United States nationals, but not citizens. We are here today, Your Honors, to oppose the judicial imposition of citizenship on the people of American Samoa for the following 3 reasons. First, imposing citizenship on American Samoa would violate their right to self-determination and threaten their cultural practices. Furthermore, the American text, Constitution, and structure all support a finding that birthright citizenship should not be extended to American Samoa. And finally, petitioners' avenues for relief does not end today, as they can individually choose to pursue citizenship through the streamlined naturalization process in place of them. Now, the legal isolation of American Samoa is pivotal to preserving its culture. In Boumediene, this court recognized that citizenship is a key factor in determining which constitutional provisions apply overseas. And imposing citizenship, regardless of the people's wishes, threatens social structures, traditional practices for land alienation, religious customs, all of which are legally protected by the American Samoa Constitution today. Now, the Constitution of American Samoa expressly says the government shall protect persons of Samoan ancestry against alienation of their lands and destruction of the Samoan way of life, Fa'a Samoa. Now, the Matai system in Samoa organizes households according to large extended families. Traditional practices such as land alienation, the social institutions of American Samoa revolve around communal ownership and management of land for the good of the community. More than 90% of the land in American Samoa is communally owned, and the alienation of such land is strictly regulated. Samoan law restricts the sale of communal land to anyone with less than 50% of Samoan ancestry. This unique and complex relationship with the land is what the Samoans sought to protect during secession, and that is shown by the current lack of consensus between American Samoan people on whether to ask the United States for birthright citizenship. Unlike the United States, American Samoa has a homogeneous religious culture. 100% of Samoans report being Christian. Religious observance is enforced by local leaders. There is both early evening prayer, curfews, and nocturnal curfews. A curfew aimed at all citizens may not be able to survive constitutional scrutiny. And in Zorak, this court held that the Establishment Clause prohibits government from making a religious observance compulsory. There is a question of whether birthright citizenship would require abandoning these traditional practices, practices which the American Samoans hold so dearly to them.
So you made quite the case for ending this relationship, but but I'm curious, from your perspective, given the current relationship as it existed for quite some time, beneficial to our government and American Samoan people, as you've described it, what exactly? I understand your point about it might not survive scrutiny if citizenship is imposed. Is there any way to gain some benefit of citizenship even with the current status? In other words, is there some part of the legal protections and guarantees that are constitutionally based that might be directly connected to citizenship that nevertheless the people of American Samoa enjoy now? Or is that all contentious and has to be negotiated with Congress?
Well, I believe that's exactly why the petitioners are here today, to argue for the benefits and privileges that come from citizenship. The issue here is that their position does not represent all of American Samoa. And while I do admit in 1930 there were discussions, as petitioner has said, about seeking citizenship for the American Samoan people. However, what I would argue is more probative is the last 60 years, pointing to when the American Samoans first instituted their constitution. They never bargained for citizenship. They never bargained for more representation. Rather, they unilaterally decided to promote this constitution that supported their practices.
Well, counsel, on that point, if American Samoans are not recognized as citizens, isn't the petitioner correct that the petitioner is a citizen of nowhere, not even France, right? Shouldn't we? I was not expecting France reference today. Shouldn't we avoid an interpretation that results in the creation of stateless persons?
While there is an understanding that they are a citizen of nowhere technically, they do enjoy the benefits of U.S. nationalism. And so if they do choose to seek individually the right to be a citizen somewhere, then they can pursue to do that through Congresswoman Amata's recent push for streamlining the naturalization process.
But counsel, how can that be the remedy?
Well, we would argue that the opposite of the remedy is imposing judicial citizenship, not through the will of Congress, which has worked with the American Samoan people for the last 60 years in deciding what their trajectory should be. Rather, this court, sitting 7,000 miles away, would impose a situation on American Samoans that there is no majority consensus on, such that they would wake up the next morning and realize that they're citizens of the United States.
And then how is the process even expedited? Can you address that?
Yes, well, the process is expedited such that American Samoans do not have any residency requirement or the need to stay longer than 3 months in a place before they seek citizenship. Further, they can enter the U.S. freely, leave the U.S. freely. They're allowed to serve in the armed forces, which, again, I respect your point from earlier regarding the ability to shed blood for a country but not seek their citizenship. But the point here is that the American Samoans at large, their will, is not to be American citizens. And it is the irony of that, of the insular cases, which have been criticized for their racist and wrong beliefs, the irony would be to impose judicial citizenship on these people against their wishes.
Well, let me ask you this. What if there's a referendum? Let's say we agree with this side of the argument, and a month later, after our decision, there is a referendum, and apparently the tide has turned. What recourse do they have? Going to Congress and trying to negotiate citizenship
Well,
via statute?
So the American Samoan Constitutional Convention will actually be held in the upcoming year, and this is dialogue that is to be addressed there. So I think the point is that their opinions could change tomorrow. They could change in the next 48 hours, but it is on them to decide what their opinion should be. And if so, they would go to Congress, just as Congress has done for every territory on a case-by-case basis, and request citizenship and go through the democratic process that's in place right now. The 10th Circuit did...
And then let's say they get the citizenship. A year later, they say, it's not quite what we bargained for. We're not so happy. Is that, and I don't mean that really tongue-in-cheek, I mean, is that what you're advocating for, this kind of political back and forth as the tide moves? Or is it once citizenship is, if citizenship is recognized, then it's permanent?
Well, exactly as petitioners argued, if American Samoa was unhappy with their decision, they could secede, just as the Philippines did. And so I think the point here is that likely citizenship is a very complex process. It's something that is put a lot of thought into. And so likely 48 hours from now, the decision will not change. And as you said, a year from now, it will not change either. Right. But if that were the case, that would be up to the will of the American Samoan people to do so.
Counsel, it seems like we're leaving the people of the American Samoas with a lot of uncertainty. The definition, as I'm hearing it for you, the birthright citizenship should apply through self-determination, right? What other individual rights should be left up to the political process? And as my colleague mentioned, the winds of political change. It seems like there's a lot of uncertainties. What standards are used, or is it all political?
Well, I would argue for the last hundreds or so years, American Samoa has been living in uncertainty. But since naval rule ended, and since they established their constitution, they have taken it upon themselves to reclaim that right to self-determination, such that they can choose this process. But to answer your question, Petitioner Furumiki brought up the Craddock case. And in the Craddock case, they did apply equal protection, strict scrutiny, and they determined that the American Samoans, the most valuable and tangible thing that they owned was their land. And so that was a compelling government need which warranted this. However, if citizenship was so extended, this equal protection, this due process clause, it could lead to a stricter scrutiny in which the American Samoan people's will, their traditional practices, which not even me as a non-American Samoan can understand but respect, would be called into question. And that is a legitimate fear that they have. And
I'm sorry, I don't know if you've addressed it. Could you address this point about the expectation of the tribal leaders?
yes. Well, there is no facts in the record that support an understanding that the tribal leaders expected citizenship. However, in 1930, there was a conversation with the tribal leader in which the American Samoan people made some wishes towards citizenship. However, as I mentioned before, what I would argue is more probative is the last 60 years of history and tradition in which the American Samoan people have actively opposed citizenship. There's no majority consensus that has been reached on this front.
But I think their point is that at the time, that was the understanding and expectation. The fact that more recently there may be other sensibilities about it is neither here nor there about that understanding, what they call that understanding. I don't know if you're going to rely, like the government did, on the text of their agreement or on something else, but I'm not sure you're quite addressing the issue as they raised it.
Yes, I can address that. Well, as you mentioned before, the treaty at no point mentioned anything about citizenship, and as we all know as lawyers, when entering contracts, that is something that we look towards, bargaining our rights. And the American Samoan people, rather than asking for citizenship, cared more about the traditional practices of Fa'a Samoa, which were explicitly put into this deed of secession. And so I would argue more that that is probative of their desire to not seek citizenship at that point, nor in 1967 when they enacted their constitution. Rather, they wanted to work on preserving their cultural customs, which they feel is at threat with the case of judicial imposition of this citizenship. Now, Fa'a Samoa is more than a set of laws. It's more than a set of norms. It is the essence of being Samoan, and it is considered an integral part of those born in American Samoa. It's reflected in the original deeds of secession, as I just mentioned. They're unlike anything in the other territories. So what happened in Guam, what happened elsewhere, it's not applicable to Samoa. Samoan households are notable for their organization for large extended families. And in 1984, the Deputy Assistant Attorney General said that it had been the constant policy of the United States, partly as a result of treaty obligations and partly as a result of honor, not to impose our way of life on Samoa. This is not the first case where people have tried to force birthright citizenship on the people of Samoa. And the 10th Circuit reversed, saying that neither constitutional text nor SCOTUS precedent led to a conclusion of birthright citizenship. The American Samoan government themselves intervened as defendants in this case, agreeing with the United States and also to provide some clarity to the unintended and potentially harmful consequences this would have on Fa'a Samoa. In fact, when the 10th Circuit decision was put out, the FONO, the American Samoan legislature, they issued a unanimous concurrent resolution in support of that decision, not a single dissenting vote.
Well, counsel, you're relying on Fa'a Samoa and land and culture. Is that enough to deny an individual the right for citizenship?
Well, Your Honor, it's not. The textual analysis, however, of the citizenship clause of the 14th Amendment, that is where our legal standard comes in. Now, 14th Amendment shows that citizenship is extended only to persons born in the United States and subject to its jurisdiction. This can be contrasted with the 13th Amendment, which abolished slavery in the United States or its territories. That pivotal language of and or, if we were to disregard that, it would render it as mere surplusage, which this court has decided not to take as an option in the past. Further, I think we should look up at the historical practice. For the entire history of this nation, Congress has determined on a territory-by-territory basis when to extend such citizenship. And in Waltz, this court said that unbroken practice is not something to be lightly cast aside. Finally, there are no special circumstances which would warrant such imposition of citizenship. There is an ongoing democratic dialogue on those issues as American Samoans and their elected representatives work with Congress. Ultimately, birthright citizenship is afforded to the people of American Samoa nowhere in the Constitution, and imposing such citizenship would be contrary to the wishes of the people. It is not within the text, the four corners of our Constitution, and the streamlined process afforded to American Samoans allows petitioners to pursue their wishes without imposing a requirement on all American Samoans against their will. And for the foregoing reasons, we request this court side with the democratically elected government of American Samoa. If there are no further questions, Your Honors, I rest. Thank you.
Thank you. Petitioner rebuttal. Counsel.
Madam Chief Justice, and may it please the court. We would like to address something that the first respondent had said. They said that their common law conception of citizenship, they agree with the petitioners, is tied to Wampanoag. We thank them for this concession because in reality what they're saying is that Wampanoag does not resolve the geographic scope of birthright citizenship. We warn this court against this revisionist account and revisionist understanding of the 14th Amendment itself. At the time of the enactment of the 14th Amendment, the framers were very clear in the textual basis of what it meant to be an American citizen. Now, the respondents resort to the 13th Amendment as a historical basis or as a contemporary evidence for why they believe that the conception of citizenship was not extended to United States territories. But this reliance on the 13th Amendment actually puts them in a bind.
If someone who is a descendant of people born in American Samoa, but who was born in New York, aren't they the person that's equivalent to the person in Wampanoag? Isn't that sort of the match as opposed to trying to put this square in that round hole that you're doing now?
It might seem that way if Wampanoag was narrowly decided, but Wampanoag was not narrowly decided and very much upheld a common law tradition that came from British history in understanding the textual history behind Wampanoag and the precedents that it supported. We look at other cases as well that upheld this narrative to show that this was not narrowly decided just for citizens of a state, but inclusive of territorial persons as well. We look, for instance, at the case of Miller versus Albright, in which Justice Scalia's concurrence said that a person born outside the territory of the United States must be naturalized, and therefore persons within the territory of the state under Wampanoag did not require naturalization. We looked at the case as well of Whedon versus Chim, in which it's stated that the Wampanoag established at common law the rule with respect to nationality. And so we'd say that the reliance on Wampanoag is something that has its basis not only just on a narrow understanding of citizenship with regards to statehood, but with regards as well to territories outside the United States. Now, I want to briefly address also something that the amici for the respondent had addressed, which is the importance of preserving the culture and the heritage of the American Samoan people. Now, this is the sort of repurposing argument, again, that lends credence to this revisionist account of what the 14th Amendment meant. We actually looked at repurposing the insular cases to accommodate culture would be like repurposing Plessy and creating a precedent in which people rely on something that has racially benign classifications of what citizenship meant.
The difference is the people themselves are deciding for themselves what is best for them, right? That I think is the point that counsel was trying to make. Unlike slaves, former slaves who are trying desperately to be treated equally as is promised to them.
I think my co-counsel actually responded to that quite well, and I just wanted to finish that point because I understand that we're out of time. But my co-counsel very much described that as something separate. The quest for independence is not something that we're trying to take away from these people. Rather, what we're looking for is what the current status is to remedy the harm that currently exists in which they are citizens of nowhere. And we want to leave the question of independence as something in dialogue with Congress and the people of American Samoa to address. With that, I stand. Thank you.
Thank you, Counsel.
Thank you all. To all of the law students for that wonderful argument. Great job. We are going to allow the judges 5 minutes to deliberate and then come back with their findings for us. And then after that, we'll go to the reception. So 5 minutes, judges, to deliberate and come.
Maybe they can step back.
Yeah, they can step
It'll
back.
make it faster. Thank you everyone for staying, for what the three of us are absolutely unanimous on, that this has been a very engaging moot court, that we are thoroughly impressed by all of the students. I will, yes. I don't think I'm overstepping my role here on saying we do hope to receive clerkship applications for the state judiciary, certainly at the Court of Appeals. I have a colleague in the back who may be interested too. Anyway, we found you all very, very impressive. It was, we will say, a difficult choice. You may have seen us call Ernesto over because we were trying to negotiate, as I'm sure the people of American Samoa have throughout time, a way that we could make this easier on us. But apparently we too must succumb to the rules of the moot court. So we're each going to say something about everyone first, and then I'll announce the winning teams. How's that? So again, in addition to what I've already said, I found all of you really very impressive with your arguments. You knew the cases. You stuck your guns under some very challenging questioning. I thought even the setup can be a little bit difficult and off-putting, and yet you really held your ground, stuck to your role, and with great aplomb, I think, called us out when we misunderstood history or a case, and that is what you have to do. You're representing your client. You've got to find a way not to insult the judge, but to let them know they're wrong. In your view, and hopefully your view is persuasive. But I meant very sincerely, and we were saying that in the minutes we had. Very, very impressive, and it is a very complex, interesting question, and we're very grateful that you shared with us your approach to the issue. So let my colleagues speak. Justice Kennedy.
One key point is that when a judge poses a question, answer the question. And I must say that all of you were responsive to the judge's questions. Also, there were times when we threw curveballs at you. You did not flinch. You held your ground and you answered the question. Also, I like the fact that you knew the law. Thank you. You knew the law, because very often in real life, and my colleagues can tell you, there have been briefs where the cases have been miscited. They do not know the case, and it was obvious that you knew the case, you knew your argument. Another thing that I really liked about all of you, and I may approach some of you individually, that you had a story, a theme that is so important, and you took us down a road with the theme. And I don't know, I was like, I don't want to pose a question, because I was really listening to you and taking notes. And I think I will approach you individually about the things that I wrote about each one of you. But another thing is, you probably heard this term, fake it until you make it. I'm sure you've heard of it. And it was clear to me you were not faking it. Yeah, let's clap to that. So, and I have to say this, because in the first department, and probably in all of the appellate divisions, certainly Court of Appeals, women, do we see them? Not a lot. We're so proud to see you. And certainly to see a man of color, I must say, it warmed my heart. Now, I'm not singling you out, okay? But the fact is, listen, I just have to be real, okay? And the fact of the matter is, all of you, and I'm gonna stop, but I was so proud of all of you because I think all of my colleagues will agree. You presented yourself better than a lot of the people that have been in practice for quite some time. We'll leave it there. Congratulations. So proud of you.
You know, quite often, in fact, I almost never do it, but I'm going to do it tonight. I never reveal confidential discussions with other judges, right? But I will tonight only because it's so special. When we turned our mics around and huddled, it looked very judicial, right? What we said was, oh my God, was that a great argument or what, right? How are we going to make a decision, right? So you forced judges to do the one thing that we don't want to do, which is make a hard decision, right? We were hoping that it was one-sided, but it wasn't one-sided. So kudos for you, right? Oral arguments is an art and a science. Never did I believe that you were not going to come here prepared to argue the law, right? Because that's what you were doing. You woke up, you're like, I'm going to argue the law. The art part of it is to incorporate that into arguments. We read the materials as well, right? It's the dialogue that we wanted. And the cadence, the way you responded to us showed that you understood that art part, which takes a while to develop, and you have to do it through reps. So I'm very impressed that you were able to do it through an academic exercise, and really, that's sincere. So congratulations to all of you.
So without further delay, and again, it was a very difficult choice, which speaks to the strength of both teams, not to the weakness of any individual. The winning team is the government and American Samoa, excuse me. And second place to petitioners and Amici for petitioners. Thank you so much.
All right, thank you, judges, and thank you, students. Now I will let you all go and head to the presidential reception in the ballroom to the left. Thank you.
We want a picture with the